welcome to Web3 Tuesdays, the first webinar series in law and Web3. First of all, sorry for those who joined a little bit earlier because we did have a slight issue with Inventbrite, but thank you very much for being with us anyways. So before we start, as always, a few housekeeping issues and housekeeping matters. So this session is recorded. So if you don't want to appear on the video that we will publish on our YouTube channel, please consider switching off your cameras. But otherwise, you're more than welcome to keep your cameras on. Please also mute yourself during the presentation, and at the end, we will have, as always, a Q&A session where you can raise your hand and mute yourself and ask the question, or alternatively, you can also put this question in the Q&A or chat box, and we will read it out loud for you at the end. So that was the administrative part, and the exciting part today is that we're exploring the IP in the Metaverse with not one, but two fantastic speakers, Pauline Debré and Laetitia Nicolazzi from Linklaters. So Pauline is a partner and the head of the intellectual property practice at Linklaters Paris. Laetitia is a managing associate at the same firm. So Pauline and Laetitia both advise clients on very high-profile and cross-border contracts, transactions, and disputes. They notably practice trademark, copyright, patent, and trade secret litigation. And Laetitia also has extensive experience in the gaming industry. So we're very, very excited to learn from you, Pauline and Laetitia. The floor is yours.
Thank you very much, Ekaterina, for the invitation. We are very happy to be here today with you to discuss the links between IP and Metaverse. It's an important topic as the Metaverse presents both risks and opportunities for IP rights owners. And we've had many questions from our clients on the topic so far. So maybe we propose to start by giving you a quick definition of what we mean when we refer to the Metaverse. And afterwards, we will present the two sides of the topic, starting first by identifying what assets or objects within the Metaverse may be protected by IP rights. And we will afterwards discuss how IP rights owners may protect and enforce their rights within the Metaverse. So does that sound good to you? Good. So
sounds like a perfect plan. Thank you.
Perfect. So Laetitia, over to you to explain what is the Metaverse. Thank you.
Yes, thank you, Pauline. It is actually quite difficult to think of a definition of the Metaverse that is able to encompass all types of digital worlds and, of course, to satisfy everyone, because everyone has a different vision of what the Metaverse is. I think that for the purpose of our webinar today, it is sufficient to describe the Metaverse as a digital world, which may or may not incorporate several technologies such as AI, blockchain, augmented reality, and virtual reality, technology that we will discuss afterwards. And also, to us, these digital worlds to be defined as Metaverse must present a few features. The first one is that the Metaverse is accessible online. That's the first criteria. The second is that the Metaverse is immersive in the sense that the user will feel involved or immersed in a digital world and will be able to wander from place to place. The Metaverse is also interactive, which means that the user can interact with the world he steps in and also interact with other users. That will depend on the specifics of the Metaverse, but it is usually the case. And finally, the Metaverse is live and persistent in the sense that when the user is not connected, the digital worlds continue to happen and to evolve. So I think one point we wanted to make sure that everybody understands is that there is not one Metaverse, but rather multiple Metaverses with different purposes or characteristics. And each Metaverse will be handled by a platform, and each platform will be very different. And to give you a few examples, you might have heard of some Metaverse, such as Decentraland, Meta, or Sandbox, which are the most famous. And based on the definition I just gave, some video games could also be considered as Metaverse, for example, Fortnite or Second Life. So because we weren't sure that everybody here would know what we were talking about, we prepared a short document with images just to give you an idea of this kind of different metaverse. So I will just try to share my screen to show you that. Okay, can you actually see the Word document?
Yes.
We can.
Thank you. So that's an image taken from Decentraland. So this is the view that you would have as a user. That would be your avatar, and that's a shop when you can actually do shopping. This one was taken out of Sandbox, so a little bit different in terms of graphics. This is Meta Horizon World, which is a metaverse mostly focused on being able to work in teams and organize group meetings. And this is Fortnite, so that's a video game, and that's a picture, well, not actually a picture, but a screenshot of a concert that was given by the avatar of Travis Scott within Fortnite. So that was just to give you a few ideas. I will stop sharing here. So now that we have defined what we refer by metaverse, the first question to address when speaking about IP and metaverse is actually to determine on what objects or assets we find IP rights. We find IP rights within the metaverse. So first, and to take a step back, the equipment that will allow users to accept the metaverse may give rise to some IP rights. For example, the technology behind the VR helmets can be protected by patents or design for the shape of the helmets. Similarly, the computer programs or the code that will allow generating virtual worlds and permit interaction between the users and the worlds can also be protected by copyright. We will not talk about that much because in terms of equipment, there is nothing specific to Metaverse. So we will go straight to what's interesting when talking about IP and Metaverse, i.e. the creations that will be generated within the metaverse. So this may refer to two different situations. First, the platform owner, like the metaverse platform owner, will create a digital world. And the graphical interface, so everything you will see on your screen, so the settings, the trees, the house, the characters, every object that will be included in the metaverse platform or in the video game, because it's the same reasoning. For example, cars, weapons, clothes, etc., may be protected by copyright. And such copyrights will usually belong to the creator of the metaverse platform or the video game publisher. There is another thing that is a little bit more tricky in terms of IP rights. It's what we call user-generated content. In some metaverse platform, the user of the platform will create a basis and then integrate a software that will allow users to produce new elements by themselves. So these new elements can be varied, such as just creating a house. I was mentioning that earlier, creating a new avatar, that kind of thing. In this case, the question of who will own the copyright on user-generated content is usually dealt with the terms and conditions of the platform, because each platform will have terms and conditions with different stipulations. It is quite frequent that the company who owns the platform or the video game will require at least a license on such assets and sometimes a full assignment. For example, we had a look at the terms and conditions of the Fortnite video game. And these terms and conditions provides that the user gives Epic a perpetual and free license to host, copy, import, store, modify, etc. So basically, doing everything that Epic wants with everything that the user will generate within Fortnite. So we talked about creation generated within the metaverse. Another interesting thing in terms of IP in metaverse is the question of assets that exist in the actual physical world and that would be imported or reproduced within the metaverse. So to give you a very easy example to understand, You can think, for example, of a painting that would exist in the real life, and then someone would want to reproduce, for example, to have in his metaverse virtual house. Another example is the example of the trademarks. So I showed you before an image of Decentraland, and you could see the shop. On this shop, I think there was no specific brand, but you can imagine that someone, maybe the owner of a trademark, or maybe someone else, and that will be a question for Pauline later on, will want to create a shop and put a trademark on the front of the shop. So, for example, a Nike shop within the metaverse. And I think that's a good transaction for Pauline, who will explain how IP owners can protect and enforce the rights within the metaverse.
Thank you, Laetitia. So indeed, that's the key question. And just to make the link, of course, it's not because you own the IP that you are always able to use it. Sometimes there are existing works, and so that's another question. But just to make it clear, whether or not the terms will allow you to be the owner of the IP does not completely solve the question of what you can actually use with or without authorization. So coming to the question, which is how do you enforce your rights in the metaverse? There is one difficulty, which is a major one, which is the fact that IP rights are by essence, by nature, territorial, sometimes regional, but mostly national rights. And by opposition, the metaverse has a global coverage. So that's one difficulty. This question of how do you enforce your IP rights has been heavily discussed in relation to trademarks. And so the question that was raised was the following. So let's say you have a trademark covering a shoes brand, and you decide to call it Chouchou. So you will probably register the Chouchou trademark in class 35, so for shoes. And now imagine that someone in the metaverse creates a digital shoes shop with the same brand, Chouchou. So are you able, with your trademark covering only physical shoes, to oppose such shoes in the metaverse? And so the answer will depend on the type of products that is actually being sold within the digital shop. I will not enter into all the discussions and very detailed explanation of the criteria for trademark infringement, because again, it will depend on which applicable law you will use. But to make it simple, if this digital shop allows user to buy actual physical shoes that will ultimately be delivered to their door, then yes, as the owner of the prior identical trademark, you will be able to launch a lawsuit and obtain an injunction. If, by opposition, the digital shop only allows to buy digital shoes, for example, NFTs, can you oppose such use based on your trademark, which again covers only physical shoe? And that's the question that has been discussed in many cases. One of them is a quite famous one, and you've probably heard of it. It's the Meta Birkin case. And it was in the spotlight a few months ago. So the case was about the luxury brand Hermès and its very popular bag Hermès Birkin. And the French company sued the American artist Mason Rothschild for creating and commercializing in the metaverse around 100 NFTs, which were associated with the reproduction of the shape of the notorious Birkin. And it was not cheap, because it was $5,000 each NFT, so not the real price of a Birkin, but still. Maybe Laetitia, just to illustrate the kind of NFTs we are talking about, you can show an image of a few of them.
Yes, I think I'm sharing my screen right now. Can you see it?
Yes.
We can.
Thank you. So Rothschild's NFTs were called Meta Birkin. So there was a question of trademark infringement with the use of Birkin, also potentially copyright with the bag. But we understand that the case was brought before the court on the basis of trademark infringement, false designation of origin, trademark dilution, cyber squatting as well, because they had registered a domain name. And so the complaint was examined by the court, and in defense, Rothschild filed 2 motions to dismiss, arguing that the use of the Meta Birkin sign was allowed under what we call the test, Rogers versus Grimaldi test, which is based on the First Amendment. And basically, this allows to use a third party's trademark if such use is, I quote, artistically relevant and does not explicitly mislead consumers. So to put it simply, Hermès argued that the Meta Birkin NFTs infringed Hermès trademark by leading consumers to believe that Hermès was associated with the NFT collection, and that Rothschild was benefiting from that confusion. And in defense, Rothschild claimed that it was a form of artistically relevant expression. They wanted to denounce a few topics, and so it was not. It was a kind of a protected form of speech. So ultimately, it was a big win for Hermès in February of this year, because the jury determined that the First Amendment did not allow Rothschild from liability for trademark infringement, and the jury awarded Hermès a few hundred of thousand euros in damages, not a lot compared to the amount that was requested, but still the case is still pending because both parties have filed new lawsuits, so it's still a very hot topic. So this was for trademarks. So lots of questions around, using only these. So putting something from the physical world in the metaverse. We also have issues around copyrights, and in terms of copyright enforcement, as long as there is the reproduction of a copyrighted work in the metaverse, it should amount to infringement. Then there is an additional question of whether there is an access to the public, which could constitute an additional act of infringement in terms of communication to the public. But the mere reproduction of a work which is protected by copyright in the metaverse is normally sufficient. And there are, of course, lots of different copyright laws, but also some harmonized legislation, such as the Berne Convention, which was amended to include the use of protected work in a digital form, such as an NFT or a file in the metaverse. But it's true that we still see some differences. And again, the question of the applicable law will have a huge impact on where and how you can enforce your rights. Because, for example, US law, French law is much more protective than US law in terms of copyright, because in the US you have the notion of fair use. And in France, we don't have that notion. We don't have any case law yet in France on the metaverse, but we have a decision which is interesting to mention, because it was a comparable situation, because the Supreme Court ruled on the reproduction of a car in a video game. And the question was whether or not it could constitute copyright infringement. In the specific case, the ruling denied infringement because the characteristics of the car were different. It was Ferrari who was suing, but the decision makes it clear that copyright can happen in a video game context, and so, of course, is the fact in the metaverse context. But for a similar situation, so using a car in a video game, we found some US decisions one involving AM General against Activision Blizzard, related to Call of Duty games that show quite some difference in terms of assessment of copyright, because in this situation, the use, it was a truck in the video game was considered as having artistic relevance and not infringement. So again, some differences. So Metaverse is not the Far West. There are some existing laws, but still the lack of harmonization and legal rules make it a bit difficult in terms of enforcement, and also in terms of detection of infringement, because first you need to detect infringement, then you need to identify the identity of the infringer, and usually blockchain grants privacy. So maybe we'll come to that a bit later, but that's also a difficulty. How can you sue the right person once you've detected infringement? Because of these difficulties in terms of applicable law and jurisdiction, there had been some initiatives, and maybe I will hand over back to Laetitia to mention a specific initiative, the MetaCourt.
Yes, we wanted to mention the MetaCourt because we thought it was quite interesting and might be interesting to you as well, Katia, as it relies on arbitration. Actually, I tried the platform, so it's called MetaCourt, and they are aiming at resolving disputes in relation to Metaverse, NFTs, and blockchain through what they call on-chain arbitration. So how does it work? If you're a plaintiff, you submit your arguments and evidence to the MetaCourt platform. The MetaCourt platform will select a group of what they call panelists or arbitrators based on their previous knowledge assessment and good reputation within the platform community. Then, if you are selected as a panelist, you log in into the platform. You have a description of the case, and you can review the evidence and the argument presented by both parties, and then you vote. Every panelist votes, and then the case is decided. And if it's possible, then through smart contract, the decision will be automatically executed. So it's an interesting process because it's, well, I think the main advantage is that the panelists will have knowledge of the Web3 and the technicalities of the blockchain. So it's interesting to have a specialist deciding your case. What I found a little bit weird is that in order to be voting, so as an arbitrator, you have to stake, well, their money, the MetaCourt money. And if you vote as everybody else, then you will get rewarded for that. But if you don't, then you would lose the money that you had stacked. And that's a bit counterintuitive for us that we do litigation in our everyday work, and where a judge, I mean, I hope are aiming to get the best decision and not the decision that everybody else would have. So I think it's interesting, but it needs to be refined a little bit in terms of rewards that can be offered to the panelists. And back to you, Pauline, if you want to mention the other difficulties in relation to enforcement.
I think we've covered the main aspects. So I would, given the timing, maybe ask Ekaterina if we have questions.
So indeed, so thank you very much for the presentation. I think it was very great, very dynamic, and I think the best proof of this is that we do have a lot of questions. And I also find that we can't have them all. So probably, is there anyone who wants to ask their questions by unmuting themselves? If not, I will just read them out loud for you. But does anyone want to ask their questions directly? No, okay. So I will just go to the chat box and I will just start with the, yes, please.
Hi, can you hear me? Yeah. I'd
can.
like you to just touch upon how to start enforcement from within the metaverse, if possible. Just if you can just touch on it in a nutshell, I'd be grateful.
I'm not sure I heard the question completely. Could you please repeat it?
How can you start enforcement? Is it the question?
How do you start enforcement against an avatar within the metaverse?
Well,
Yeah, please go ahead, Laetitia, if you want to.
I was just going to say, actually, that's the tricky part, because first you need to identify the actual person behind the metaverse, behind the avatar, sorry, which is not easy. And then you need to find a way to find his address, for example. So we have heard of cases in the US and in the UK where the courts actually accepted service through wallets. So that could be a way to actually initiate enforcement against an avatar, but in any event, you need to find the wallet address to do so. So I think initiating the case would actually be the hardest part. I don't know what you think, Pauline.
No, I agree. And then again, it's a question of which IP right and which applicable law you can apply to the infringement. And ultimately, you need not only to identify the infringer, but also go to an ordinary court, except if you go through other dispute resolution forums. But then the question is also what type of sanctions can you obtain? And on that, maybe, Laetitia, you could say a word of the concept of burning NFTs.
Yeah, exactly. I mean, when we have a case in a physical court regarding physical products, an infringement case, and that the plaintiff will win it, usually we will ask for the counterfeiting objects to be destroyed. How do you do that with digital objects? That's a bit more difficult, especially if such object is linked to an NFT, because as you probably know, you cannot undo transactions which are already written on the blockchain. So apparently, from a technical point of view, there are a few solutions which include burning an NFT or sending it to an address that no one else can use. The question is, will judges have enough understanding and technical understanding to be able to pronounce such rulings, and also who will enforce it after the ruling has been issued? Will the bailiff be able to do so? I mean, lots of questions remain open on that point.
That's great. Thank you so much. So probably, let's say 2 more questions. So the first one is, shall IP rights be protected separately in each metaverse?
I think the answer to that is that you don't protect your IP rights in relation to a specific platform. Under French law, for example, you don't have anything to protect your copyrights, because copyrights arise out of the creation act itself. And then if you register trademark, then you register trademark by national offices, IP offices. So you don't have to do it specifically in relation to each metaverse.
Got it. Thank you. And who owns licenses and IP rights in decentralized metaverses?
So it depends on the terms and conditions, but maybe Laetitia, you want to mention a few that you.
Yeah, I think maybe the question is focusing on the decentralized part and the difficulty that we can have in relation to that. Well, the rights can be owned by DAO if such DAO would have a legal personality. And then, as Pauline mentioned, it will all be regulated by the terms and conditions. So I think the answer will depend on the specific terms and conditions of the platform we are referring to.
Got it. Fantastic. Thank you. So we do have quite a few questions more. Would you accept another one?
Sure.
Okay. Got it. The next one is, can one use the freedom of expression to use others' IP rights in the metaverse? And the related question is there any difference between trademark delusion in real life and in the metaverse?
So on the first one, the use of freedom of expression, it was exactly what happened in the Hermes situation. So they used the First Amendment to say that it was not trademark infringement, but then you need to apply the same rules. And so are there differences between trademark dilution in real life and in the metaverse? In theory, no. And the fact that Hermes was about to launch its own NFTs played a role also in the fact that the Rothschilds use was considered as a dilution of Hermes trademarks. So no, in theory, no. And again, it's a question of applicable law. And in the US, and according to US trademark law, in the Hermes case, it was decided that usual rules would apply.
And the second part of the question was about the difference between trademark dilution in real life and in the metaverse. Is there any?
No, and Laetitia, I don't know if you have a different view, but for me, it's the same concept apply. And again, depending on the applicable law.
Right, thank you so much. So it's 2:35. We ran just a little bit late, and we do have a lot of questions that probably they will leave them for the next session with such fantastic speakers as you. Thank you so much for your time. Thank you so much for everyone who have joined this session. It was really great. So thank you so much for all the information that you provided us with, for all food for thought that you gave us, and hope to probably see you in the metaverse very soon.
Thank you very much.
Thank you very much.
Thank you.
Thank you.
Bye-bye.
Bye-bye.